goes away. An offshore trust is definitely more expensive to set up and to maintain. You can figure between $5,000 and $10,000 a year just to maintain it, and upwards of $35,000 or $40,000 to set it up. And then compliance. It's a foreign trust, so the IRS requires some foreign trust compliance. It's a pretty extensive form, and it has to be done every single year. Your accountant is not going to be super thrilled if you come to him with this. So the bottom line with the international trust is if we need to use it, that's where we want to be because of its effectiveness. But before we're using it, if we're just setting it up for future possible potential use, we'd really rather not be foreign. So what about domestic? Well, they're newer. 1998, Alaska passed the first statute. Believe me, Wyoming and Delaware and Nevada were right on their heels. And today we have 19 states that have some form of domestic asset protection trust. It really is good because more than a third of the states have really recognized in a statute that taking steps to protect your assets is a legitimate, actually very valid thing for someone to do. Way long ago when I first started this, people were saying, oh, well, you shouldn't even be allowed to do it. Well, today it's pretty clear that the states feel like you should be allowed to do it. So what are the advantages of domestic? Well, cost. It's much less expensive because you have a lot more attorneys that are familiar with domestic rules and laws and are more comfortable. And because it's not foreign, compliance. There's no 3520 to fill out, so you don't have any foreign trust compliance. How about the disadvantages? Well, unfortunately, effectiveness. And this is kind of the kiss of death for the purely domestic asset protection trust. It's just not been effective. We have case law now for the 15 or so years that the domestic trust has been in existence, or the 22 years that it's been in existence, and it's all very negative. It has failed numerous times, even between two domestic asset protect trust jurisdictions like Utah and Nevada, it still failed. So I don't have a lot of confidence in it. And also control. If you really do want to try to set one of these up, one, you better live in the state that has the statute. You shouldn't live in California and try to set up a Nevada DAPT. That's really not going to work. And then control. You cannot have control of that trust. You absolutely have to give control away. So is there a better option? This is what I asked myself over 20 years ago. Is there a way that we can get that foreign protection, but have the simplicity of a domestic trust? And that is the bridge trust. It's drafted as a foreign asset protection trust. It's registered offshore. But then for the purposes of the IRS, we bring it back, we bridge it back into the United States, and we meet this two-part test, which is called the court test and the control test. And all that means is that we make it domestic for tax purposes. So we do not have to file the Form 3520. We don't have any foreign trust compliance, and we do not have to have an offshore trustee in control of your assets. Before there's an event of duress, meaning a lawsuit, there's no 3520, no 3520A. There is no FACTA disclosures, foreign account tax compliance. There's no IRS filings of any kind. Your assets can remain in the United States with your current bank, invested in your properties. You do not have to have an active foreign trustee. In fact, you can be the trustee of your own bridge trust. And it's a tax-neutral domestic grantor trust. It's treated just like a revocable living trust for tax purposes. So it's very simple to maintain. After there's duress. In other words, let's say you call Brian and I and you say, hey, I'm getting sued and it's bad. Something happened on one of my properties and it's going to exceed the insurance. It's a catastrophic thing. At that point, we have the power to trigger the trust. And what that means is that the trust is triggered offshore. The offshore trustee who's in a standby role becomes a full trustee, and you are removed as the trustee of the trust. At that point, we have all sorts of options, including moving the assets offshore. I'm going to put it together visually just so you can see it, and then we're going to stop and we'll ask the questions, and we'll leave plenty of time. So the bridge trust, let's run it against our four-part test. Is it effective? Yes. Because by the time we are using it, it's just a foreign trust, and we know that foreign trusts are effective. Control, you can stay in control of this trust right up until the moment that we need to use it. Cost, it's much more reasonable to set up and to maintain. It's very reasonable. And compliance, there's none at all. It's a domestic grantor trust. So no 3520, no foreign trust compliance, simple. So here's how it looks. You have the asset management limited partnership. That's your holding company. And then you have your LLCs. You can put property in them. You can put a boat in them. You can put an airplane in them. Anything that you need to separate out those assets. It could be multiple pieces of real estate, obviously. Those are going to be also connected to the bridge trust. The bridge trust is going to own the majority interest of the holding company. You're still going to have an estate plan, which could be a revocable trust or could be a will. And the LLCs are going to be single member, as Brian said, held by the holding company. This is great because it keeps the tax returns down. It keeps your accountant happy. It's also going to hold cash, securities, stocks, bonds, cryptocurrency, whatever it is that you want that's already in some type of securitized form. And control. You're going to be the general partner of the asset management limited partnership, which puts you in control of the assets. Ownership is going to be with the bridge trust so that we have protection. And at this point, basically, one or two things is going to happen. You're either just going to die and pass your estate through your estate plan, and it's going to distribute your assets. It's going to maximize your estate tax exemptions. It's going to avoid probate, smoothly pass your assets to your heirs. Or we reset the structure and we're going to have a lawsuit, some type of event of duress. In that case, the assets can move directly from the holding company to the bridge trust, and if necessary, can be sent completely offshore. So it's an incredibly flexible structure. It's an incredibly effective structure, and you can start at any level. For some clients listening to this, for some people listening to this, one LLC or two LLCs, one for your first piece of real estate and one for your operating company is the way we're going to start. For others of you, you probably need the entire structure right now because you have significant assets. Ferris, we'll just stop there and open it up to questions.
Yeah, great. No, definitely appreciate that, guys. It was super informative, super crystal clear up until the very end. And then, that's where I got, I have more questions. So maybe I'm going to kick it off with questions that I was writing.
Okay.
So I'm just going to maybe rapid fire a few of these, right? And I know people probably have a million questions. So if you have questions, please feel free to write them into the chat. My first question, I think this is for you, Brian. Whenever you talked about the K1s trickling in, right? All the LLCs trickle into the AMLP, but that's no different than they trickle into a person directly, right? Today, it's still the same number of K1s, quote unquote, right? Or did I miss something there?
No, they're just gonna, when you're filing your taxes, you're not filing 15 different tax returns on each individual LLC. So it cleans it up because they're gonna it's a pass-through entity. So then they're gonna pass through into that management, that AMLP.
Correct.
So you're just gonna be filing one tax return, and then it's one added page on that you're gonna be filing.
But the 15 are still having to be filed with the AMLP. Then the AMLP is issuing out one K1, I'm guessing.
Well, I think I see the misunderstanding. If you're investing in somebody else's LLC and it's a multi-member LLC, then you got to wait for that K1 for sure. But if you have your own LLC and it's wholly owned and your holding company is the only member, then that LLC does not have its own tax return and is not going to need a K1.
Correct.
So in that case, in Brian's example, if you had 15 piece projects and 15 LLCs, but they were all single member with the single member being the holding company,
okay,
then one tax return.
Got it. Okay, perfect. That makes sense. Then the next question I had was, I think this is kind of Brian's part of the presentation, but about, explain the difference to people. I've learned this from previous kind of things I've learned, but explain to them really the difference between ownership versus control. Right. I think that's probably something important for people to understand and what it means to not have control, but have ownership or vice versa. Right.
Yeah. You want the beneficial use and enjoyment of your assets. I want to be able to use my boat. I want to be able to use my car. I want to be able to go and use my rent out my properties or use my vacation properties. I just don't want to own them in my own personal name. I want to own them in an LLC. I want to have my trust own them. So that you want to separate out the personal liability from yourself and then put those assets into another ownership that's not just you, Ferris. It's not me, Brian. It's not Doug. So you want the ownership of it to be in a business entity structure wrapped around in a nice trust bubble, but you still want to benefit and get the use and enjoyment out of them.
And then what about the control piece then?
You're still controlling your assets. You still get to invest how you want to invest because you're managing those LLCs.
Mm-hmm. Yeah. Okay. And then let me ask you this question. How do you guys suggest this working in the case where you do have a partner? Imagine you have an entity and it owns multiple other entities and you have a partner at this level, right? So does each partner set up their own AMLP, right? They're getting a K1 and it's really just protecting the partner at that level, correct? Or is there a better structure? And then maybe in tandem to that, it's kind of maybe a dual question. How do you mitigate risk of one LLC essentially breaking into another LLC from a risk perspective, right?
So you're saying in the sense on if you're investing, like if you own a joint LLC, like like if you're a partner, is that what your question?
Let's say me and you have a law firm together, right? And we also have so and so company A, subsidiary B, subsidiary C, right? And so in that world, the two questions are: how should we set up our asset protection? And the other part of that too is how do I ensure subsidiary A is protected from something happening there and it coming in and impacting subsidiary B, right? Because if you really think about it, the barriers we're setting up are way up here, right? With kind of the AMLP as well as the trust that we talked about at the end. But how are you protecting it at a lower level?
Gotcha. So I would say when you're going into joint ventures, we're protecting your interests, and then we can also protect your partner's interests individually, but you don't want your partner's life mess ups to bleed into your ownership interest or vice versa. So we're protecting your individual interests in whatever partnership that you're doing. If we owned a law firm jointly, or if you owned a piece of real estate jointly, if you're syndicating, we would take on the passive side of it, we would take your ownership shares of your syndication, put them into the asset management partnership side of it because it's a passive ownership, and I would add another layer. And so what we're doing is protecting your individual ownership system, shares.
Yeah, the other thing I would add is, Ferris, it's a great question because I think there's two questions there. One is do we set up two separate plans for you and your partner? The answer is absolutely. You should have your own asset protection plan. Your partner should have their own asset protection plan, including up to and including the bridge trust if your assets deem it worthwhile. From the lower level where you're doing a bunch of projects together and you don't want one project to infect another project, that's where we want to make sure we do use separate LLCs underneath. So they are disregarded for tax purposes and they can be disregarded for asset protection purposes, but they are not automatically disregarded by any stretch for asset protection purposes. It's very hard for a creditor to sue an LLC, sue the holding company, the LLC, and then go back down to another LLC at another level. So as long as you have your systems set up and you respect those separate LLCs, that's usually enough. However, there are some ventures that are simply too risky. It's risky. You're doing something that is just, has its own set of risks. That we might want to peel off and do in a completely separate, even holding company with a separate LLC. And I do that all the time, especially with the real estate people. Sometimes we have multiple structures, multiple holding companies to represent either different partnerships with different investment groups or different partners, or just different risk categories. We have some low risk things that we'll put in one holding company with multiple LLCs, and then higher risk things that we'll put in a separate holding company with separate LLCs. So did that answer the question? Was that what you were asking?
Absolutely. I think that gave me kind of the pieces that I was curious about.
Okay.
And then there's a good follow-up question in the queue that just came up based off of that. A large audience group of this is mostly syndicators and BIAs apartments in a GP LP structure. So typically there's going to be 3 GPs and 50, a lot of LPs. So the apartment's a high risk asset. What's the best way to set up the structures that protects one GP but not the partners, simply because the other partners won't want to use your service?
Okay. Well, so it's best if all the partners agree and do it together. And I'll tell you why. Because if one partner does it and things go wrong, it's the other partners that are going to be left holding the bag. And that usually does bad things for everybody. However, if you have partners that are just not going to do it, you can do it yourself. First of all, you should not be a direct member of the general partnership. You should have a separate LLC that serves as your member of the GP share. That LLC in turn would be held by your holding company and your bridge trust. Your partner should also do the same thing. But if they're not gonna, doesn't mean you shouldn't go ahead and protect your own assets and protect yourself.
And then I'll jump in on another one that just came up about, the number of doors per LLC with smaller assets and duplexes. I would generally say we don't go by, really the number of doors. We go by what we're trying to protect, like what's the equity in it. And so, rule of thumb, we don't like to put more than 1 million, worth of equity into one LLC. So we start splitting it up there. And, especially because in states like California, it's very, very hard to get, 1 or 2 assets under $1 million. But then when you start going into other states, it gets easier. So we look at the equity that we're trying to protect and then the states. So we're not going to be, you really shouldn't be mixing assets in different states. So for example, if you have, a Texas property and a Florida property and Ohio property, those are all going to be different jurisdictions where different lawsuits come in. So you don't want to be mixing assets into one LLC there. So you would split up those assets into separate LLCs.
Got it. And then maybe a quick question of kind of the same vein though. What are your guys' thoughts on hiding the assets, right? And is that ultimately what we're trying to accomplish with these structures, or is that a whole nother thing up on itself?
Yeah, I'm really glad you asked that, because people really have some confusion over secrecy. And there's a lot of people on the internet talking about all about secrecy. You want to do all these things in Wyoming and make sure nobody can figure out where the assets are. Here's why that doesn't work. When you get into a lawsuit, at some point, they are going to have the right to examine you and ask you questions about how you hold your assets. So if your plan is secrecy and you have a bunch of Wyoming LLCs set up and you don't want to tell anybody you own them, you're one day could be under oath sitting there having to lie in front of a judge about not owning these assets. That's the quickest way to get yourself put into jail. Any asset protection structure that requires you to lie for it to work is a very, very bad plan. So
and I should go into this. Oh no, sorry, I didn't mean to cut you off, Doug.
Well, I was going to say, I'm all for a little bit of privacy. So we can set it up and we can use the Wyoming LLC as the general partner of the asset management limited partnership. We can have privacy, but you've got to know at the end of the day, privacy is not what protects assets. Asset protection works because we have the law on our side. We have the legal structure set up. And if we have to, we have the Cook Islands law on our side, which we know is going to come down in our favor. So privacy is okay. Secrecy or hiding assets at the end of the day doesn't work.
Yeah,
yeah, what I was going to say on that part of it is from, the trial side of it, because that's where I come in on it, is there's the discovery process. And like Doug was hitting on, that is just a requirement that you go through of passing along information. So anonymity works, it's nice, but it's just theoretical until you're actually in a lawsuit. At a certain point, you're going to have to step and say, hi, I'm Brian Bradley, I own that asset. And
right.
So your position is more about, it helps you avoid getting into the courtroom, but once you're in there, it doesn't do much, right? That's kind of the idea,
it really doesn't even avoid you getting in anonymity into the courtroom, because the lawsuit's going to get filed, and then
it's more so someone knowing that, if they don't know what you own, they're less likely to think that they're going to, make a big payout off of it, right? I think that was kind of the.
I mean,
no,
maybe.
I don't think that really works, because if you're getting injured on a property, I don't care who I can't find out that owns it. I'm just going to end up filing the lawsuit against whatever entity I find is owning it at that moment. And then the process is just going to work itself out through discovery. So eventually, I don't care like what the Anonymity LLC, Wyoming Anonymity LLC, or land trust does. Eventually, whoever is on that piece of paper is going to have to show up and defend themselves.
Okay, great. Perfect. That's helpful.
Hello?
Yeah.
Can y'all hear me?
Yeah.
Yeah, we can hear you.
This is Robert. So I have a question.
Hey, Robert, you want to go ahead and type your question into the comments below, and then we're gonna answer them in order for you.
Okay, no problem.
Awesome, man.
All right. Then let's keep going. So the next question came up is, in a hybrid during a lawsuit, you send it offshore. After the lawsuit is over, how do you regain control?
Yeah, that's a great question. So if we have to go to the offshore, we have to cross the bridge and go offshore during a lawsuit, we can do that. And we can do it legally because we've set up the bridge trust prior to the lawsuit. This is what Brian was saying. You really want your asset protection done before you have the problem. Then after, we have no problem using it, crossing the bridge and moving the assets. Once the lawsuit is over, then you can recross the bridge. You can bring the assets back. You can regain control of the trust. That's all possible. It's not a one-way street. You don't have to go over there and then from that point on, you're only offshore. You can always bring it back. I can tell you from experience that about 60% of the people do want to bring it back once they've had it offshore. 40% of them really like it offshore once they've gotten used to it, and they keep it offshore. But it just depends. The other thing to know is that going offshore is a last resort. The structure in and of itself is extremely strong. So I have clients call me all the time and they'll say, hey, I just got this lawsuit, Doug, we need to trigger the trust. Well, the answer is maybe we do, but let's see, let's look at it. And often we're waiting well into the lawsuit, well into probably up, when the trial is scheduled before we're actually going to trigger the trust. Because the reality is most of the time they get settled or they get dropped. So triggering the trust is the last result and only done when it's absolutely necessary.
And part of that is just because the system itself is so strong that we're not really in the game of trying to hide assets through anonymity and pretend we don't own something. We're perfectly fine, once we get contacted that you're being sued and you have your defense team coming in and saying, hey, this is the assets we have. We are not hiding the ball. We have the, migration clause. We have the bridge we can cross. We will declare, status of duress. Even if you did get that big judgment, sorry, you're not going to get anything. Just go away, or we'll give you a penny on the dollar to go away. And that's where generally the suits just disappear.
All right. So next question.
Hey, first, I want to go back just real quickly to an early question. Like Jim Workman put it in there. It's kind of a one that I think it's like a little early, but we want to touch on it. Just was, can a husband and wife create a multi-member LLC? Right? Can a husband and wife create a multi-member LLC, and how does that affect what you were talking about before, being a disregarded entity?
Yeah, a husband and wife can absolutely be the two members of an entity, and it can be a multi-member entity, or it can be a disregarded entity, because husband and wife can also be treated as one taxpayer. So often at the holding company level, we will use husband and wife as the two members, and then the bridge trust as the third member. That creates that multi-member. If we have kids, we'll use them as well. If you want a multi-member, husband and wife are fine. If you don't want a multi-member, husband and wife are still fine. You get to elect at that point. That's a great question.
Do you guys use LLCs for a majority of your entity structures, or is there any advantage to LLC over S Corp over C Corp other than tax advantages and tax implications? Is there any legality, anything that would make me sway one way or the other for an LLC or S Corp or C Corp, et cetera?
Yeah, that's a good question. So, the LLC came after the S Corp because it cleaned up some of the issues when it came to litigation and damages, because there's no shares. So in S Corp, you have shares that can be collected on. So when it comes to from an asset protection standpoint, just like a corporation, that's not good. It's good for taxes, but when you're straddling that fence, that's why when you talk to your CPA, they generally say, oh, hey, create an S Corp, because it's going to give you a tax benefit. But then when you come and talk to us, it's like, okay, we're going to clean this up a little bit, but the LLC is a better entity to hold your real estate or your dangerous assets in, because one, there's no shares to collect on. Plus they have some charging order protection. So you have a little bit at that base level layer, a stronger entity than just having an S Corp alone. And then if we ever did have to pull the trigger and cross the bridge, we can still protect those shares of the S Corp. It's just a little bit harder from the protection standpoint.
Yeah, S Corps, the way I would set it up, or the way I do set it up a lot of times, the assets are held by LLCs, held by the holding company, and then we will still have an S Corp as a management company. And then that you can run all your tax benefits through there, and it can, but it doesn't hold assets. I would not encourage you to hold assets in an S Corp. The other thing is there's restrictions on ownership of S Corp shares. Makes it a lot harder to protect, because you can't put those S Corp shares in the holding company. They're restricted. They can't go in there. They can go in the bridge trust, but when I get a client and they've already got a bunch of assets in S Corps, it's kind of a mess, because you end up with a lot of tax issues trying to get them out. We have to deal with them. If you're starting from scratch, the rules should be assets go into LLCs that in turn are in the holding company, and an S Corp should be just one S Corp as your management company. That's it.
Okay.
This is a really good one. Can an irrevocable trust serve the same purpose as a bridge trust? No. So when we were breaking down, the difference of domestic asset protection trust, One, the missing component of that is you have no full offshore component to it. So you're already now not going to be able to do anything with the full faith and credit clause of the Constitution. So you're not going to be able to have any really true judgment protection. And we're already seeing tons of case law coming through that are starting to pierce, the domestic asset protection trust strength. So even other large firms that deal with, higher end asset protection are still, saying like, if you really want strong protection, you have to add something offshore to protect those assets. And then the other part of it is just an irrevocable trust. If it's not a grantor trust, like, the bridge trust is a grantor trust. So it allows you to continue investing how you're investing. Other irrevocable trusts, like an irrevocable living trust, isn't really designed for asset protection purposes, but it then is going to limit how you can invest in, what you can invest in, and other lenders, might look unfavorable upon that. So there's a big distinction between a grantor trust, an irrevocable trust, plus a bridge trust that's an irrevocable grantor trust. So not all trusts are the same, but the irrevocable trust has been weakened, and it does limit how you invest.
And there's another question that came in about recapping the layers. For everyone on this call, it will be recorded. We will email it out. We will post it out. So I guess I'm going to skip over that question, since probably better to watch that in depth versus kind of a rushed re-explanation of that. Another question is there a limit or recommendation on how many LLCs should be under a holding company?
Oh, that's a great question. Yeah, I mean, yes, theoretically, at some point you might be overloading a single holding company if you just have a ton of assets. I mean, it's a pretty high limit. Several $1 million, still very comfortable in a single holding company. But yeah, you can get to the point where it just makes sense to have yet another holding company. It would be asset value, but it would also be risk profile. That's what we were talking about before. So let's say you have a project and it's just by the nature of the project, it's extremely risky. That might be something you want to peel off into not just its own LLC, but its own holding company. So the answer is yes, there is a limit, and it would just be individual, but you won't hit that right away, and you certainly want to start with one holding company.
Got it. So our next question, I'm going to maybe change. The question itself is how much does it cost to set up a bridge trust? But maybe I'm going to change the question around, and hypothetically, and if you guys, you don't have to answer it, but if you have a person, let's just say that they have 5 different GP interests, right? Just to throw a number out, and that's it, right? How much does it cost to take that person from having individual LLCs that he has today to kind of reconfiguring it to follow the model with the ALMP, with the bridge trust, all inclusive costs? Like what, in ballpark, I don't need to be specific, but I think that'll help people here just get a sense of, hey, is it something that they can do now or not, right?
Right. So when we look at a client, we look at the whole picture, and we're gonna prescribe what they need at the moment. Mm-hmm. So LLC and holding company, that could be very reasonable. That could cost you around $7,500 to get just an LLC and a holding company set up. Once you add the asset protection trust, the bridge trust, that's a higher level cost. The package for the bridge trust, the holding company, and one limited liability company is $29,000. And there's an annual fee of $2,100 with that. Not everybody's going to need a bridge trust. And then there's another type of trust that is very similar to the bridge trust, but that we use for clients that have less than $1 million. So if you have less than $1 million of total invested assets or protectable assets, we're going to use something called a quantum living trust. So it's very similar to a bridge trust. It's just not individually registered offshore. It's not quite as good, but to get started, it's the right tool. And then it can be upgraded to a bridge trust. So that might cost half. That might cost around $14,000. So the answer to the question is, it just depends on what you have and what you need, but that's the range. That's the high and the low of it.
You nailed the question. I think I think that gives people to really understand, kind of where there are, what fits them, what not.
Yeah, exactly. And we're going to fit it to what you need. I mean, some people call and they really just need an LLC to start, and we'll do it. I mean, just to get you going and get you with the right advice from the beginning, because we know you're going to grow.
Perfect.
Speaking of that one LLC to start, is there any legal protection from a single member versus a multi-member LLC?
Yeah, sure. I mean, we always want a multi-member LLC. If you're only going to have one LLC, you definitely would want a multi-member LLC, because now we have some charging order protection. As Brian said, we're much less likely for that LLC to get disregarded by a judge. Of course, it needs a tax return, but that's fine. There's nothing wrong with the tax return. 25 tax returns, there's something wrong with. You've made your life complicated, but one tax return you want, actually. So, the answer is yeah, if you're really just starting out, you got $60,000, you're going to go into your first project, maybe just one multi-member LLC is all you need to start.
Sure.
And there was a good question I saw pop up on insurance.
Yeah, I was going to ask that question, so I'll read it. So what role can, if it does, insurance play a role in asset protection, more specifically umbrella insurance policies and in-house captive insurance?
Yeah, and so I see a lot of clients that have a false sense of security, whether like umbrella policy or not, regular insurance, or not thinking that they're, if they're going to get sued, they can just solely rely on their insurance to cover them. And it just isn't the case. It's not how the insurance business as a business makes money. It's not how insurance law works once you're in a lawsuit and the legal team takes over. We do recommend, I do recommend that every single person get insurance and have as much as you can afford. But they also need to read the insurance policy, know your fine print, understand what's not covered in the, and what your actual claim limit is. And so a good place to start is just to actually first understand that, real estate is going to be a heavily litigated area of law. And then also just understand that insurance companies don't cover you for fraud, punitive damages, or intentional wrongdoings. They don't pay claims that are going to be what's called the direct result of unlawful acts. And when you're going to get sued, and I'm going to sue you for example, there's going to be one of those intentional wrongdoing elements in there, because I'm going to punch through that insurance. I may want to add, get a settlement from the insurance, but on large claims, and I know you have a lot of assets, I'm going to try to get to you. And so what the listeners need to understand is that, the basic concept of insurance defense, you can be sued. And from the very first statement or a communication that you make, an email that you send out, that's going to be put into, the lawsuit. And then a judge is going to look at that email and say, well, that's a statement. Statements are intentional acts. This is now going to be considered by your insurance company intentional acts. And so they're going to sit there and say, well, we're not going to cover you in a case that's potentially where you did some intentional wrongdoing. If you don't like it, go ahead and sue us anyways. And so that's how this game is played out in court.
Got it.
Yeah. Buy insurance. Don't count on it 100%. It's not going to work always the way advertised.
All right, so I want to be respectful of y'all's time, so we'll probably do 4 more questions, and then we'll wrap up about 8:40 Central. And then for those, and I would love for you guys to stay on. I don't know what your schedule's like, but we typically do breakouts where we will randomly distribute the group into kind of small groups of 7, 8 people, and people can have more of one-on-one. So we will do that. We always do that, and so I'd love to you guys stick around. But otherwise, I'm going to ask these next 4 questions, and then we can call it a wrap on that. So first question is, I invest out of state and the properties are held in jointly owned LLCs. The properties are held by a Wyoming LLC. Is this adequate?
How many are I would say it's limited right now. You at least need to, I would recommend having, I don't know what the equity is. So if you have, 4 properties and each one's worth $1 million, or an apartment complex, I'd have, okay, we have to figure out what the equity part of it is. But I would at least think that you should add a second layer, either get a second LLC to operate out of, or add a management company, from there.
Yeah, and is the question that it's Wyoming and you're using it for assets that are not in Wyoming? It's okay. You haven't done anything wrong. You're not really getting any benefits for the LLC being in Wyoming, because when they sue you, they're going to sue in the state that the property's in. So it's okay that you used a Wyoming LLC, but you didn't buy yourself anything.
All right. And I think we answered the question about irrevocable trusts serve the same purpose as a bridge trust. So we'll skip that one. And so the next question is, in terms of what you mentioned regarding irrevocable trust, is that equally applicable to DSTs? Same drawbacks?
So the Delaware statutory trust is really a California thing that we use for people who hear about series LLCs and they like the child series that break down each asset in the little child series underneath the the big parent company. But you're not getting any extra protection out of it. What you're doing is just doing a tax planning, because you don't want to pay the $700 annual tax fee per LLC. So you're not getting any extra protection. Plus you got to get a side operating company, because you can't operate out of a DST to hold real estate. Otherwise you're going to lose the IRS tax definition of being a business trust. And then you're completely opening up the door for liability.
All right, next question. Can you give me an example of what you might consider a risky asset?
Anything with a door, a lock, a key, an engine, a propeller, anything that can hurt anybody. Definitely every piece of real estate that you own and every
You buy
vehicle that
something
you
that
own.
needs insurance. Yeah, if you need insurance on it.
Yeah. Yeah. If they even sell insurance for it, it's a risky asset. A business, the businesses are risky assets. All of those things. The only thing that we wouldn't consider a risky asset is an investment. Apple stock is not a risky asset. Nobody's going to slip on your statement and sue the owner of the account. So, but anything physical is a risky asset. So, really good question.
All righty. And then last but not least, can you use a series LLCs for holding property? Is that a good LLC structure to use? Not sure if it's available nationwide or not. I know you guys kind of touched on it, but maybe if you want to.
Yeah, we touched on it, and I'll just break it down. So I'm reading the question right now. I'm not sure if it's available nationwide. No, it's not. Not very many states have series LLC structures. So if you don't live in a series LLC friendly state, and the asset that you're owning is not in a series LLC friendly state, I wouldn't recommend using them, because then what happens when you get sued? They're not going to be recognized. So it just depends on where the asset lies and where your residency is, and then we just look at it from there.
And I'll give you just the quickest story. I had a California guy call me. He had a series LLC. He did in another state. He put it in California, bought 3 separate $1 million properties, ended up with a mold claim that was going to be $5 million, went to his attorney and said, hey, I have series LLCs. His attorney said, yeah, those don't work here. Irrelevant. And all his LLCs were considered one LLC. So all $3 million in property value was subject to that lawsuit. So the answer is don't use them unless you're in the state and the property's in the state, like Brian said.
All right. And before we wrap, I'm going to ask you guys one more question that wasn't asked, but I just made me think of it. Most interesting story you guys have to share. Let's put it that way.
Oh, jeez.
You guys have probably seen some interesting things, done some interesting things. So
well, okay. So I'm going to put it this
kind of
way. The thing that you're thinking about that's going to cause the liability, 80% of the time is not going to be the thing that you call us about that did cause the liability. Because the thing that is going to happen is just not on your radar right now. It's not happening. And so when you said interesting story, I'm thinking about all sorts of crazy stories that I hear all the time relating to things that are, I mean, I don't even really want to repeat some of them because they're crazy things that you think, wow, that's just beyond the pale. But I can tell you the biggest issues are interpersonal issues, partnership issues, things that really, it's not what you think is going to happen. It's not just your tenant that is going to have a problem. It's a partner that you dealt with, or it's somebody that you work closely with, or it's your personal relationships. So I'll just kind of leave it at that.
Yeah, and that's kind of a good one. There's a lot of crazy lawsuits, but it's always the ones that wipe people out where you don't know what you don't know. You didn't know what you didn't know. And so you can't protect yourself from that, if you don't plan ahead. And so I think that's what this is really about, is just getting the system, no matter what life hiccups come your way. But, like there's doctors who, you're a surgeon, you make good money, you're also investing. And then next thing you know, you nick an artery or something, and then you got a $5 million claim and you only have $1 million, coverage, which most doctors carry. Now what? And so without the system, you're going to get wiped out and lose your practice. Or people don't realize you own your own practice. Maybe your malpractice is, not that big of an issue, but your business is. And so you got to realize where your liability comes from. It may not just be what you're doing at the moment in a business, but it could be other areas, or it could be not at the investing part of it, but your business structure that you have. So that's where you need to really, talk to the professionals and say, like, all right, let us look down and see where all your risk and liability really is. And let's start talking through what you don't know that you don't know.
Awesome, guys. Well, Brian, Doug, thank you very much. Definitely enjoyed it. I know super valuable information for me. I'm sure other people, it sounds like from the comments, definitely people got a lot of value from it. We will absolutely share out the recording. We'll definitely share out Doug and Brian's contact information as well. Please reach out to them if you guys have any questions. What was that, Garrison?
1 second. Yeah, 1 second. Do you guys happen to have a copy of this presentation? We hit the record button about 15 minutes into it, and
yeah, absolutely.
This was phenomenal. This was absolutely awesome. Like, we're going to get so many requests for this.
Yeah. We'll send you a full copy of the presentation and you can integrate it
Perfect.
into the recording.
Absolutely. Thank you so much for showing up, man. This was
Yeah,
great.
and I did
thank
see
you
a
guys.
question. Are you in California? Brian and I, we work in all 50 states. Most of what we do is not necessarily state specific. And then I have affiliate attorneys in all 50 states if we ever do need local counsel. So question is, yes, we can work with you. And if you're in
Yeah,
any
I
of
was just
those
writing
states.
that into the chat because I
Yeah.
wasn't sure if we were
Hey,
Well,
Brian,
if someone
do you
wants
want
to take you guys out to coffee, where's home?
Oh,
I'm,
yeah.
I'm home in Portland, but I practice a lot in California because I'm licensed all over this country. I represent clients a lot of places, but out in Simi Valley area is where I go and visit my family a lot. So
Hey,
do
Brian,
you
do
wanna
you
have
want to
coffee
throw
with
your
me?
contact information up one more time with your
Okay.
screen share?
Oh, yeah, sure. Okay, is it up?
And Doug, where are you located?
So if you want to have coffee with me in the summer, you're going to have to come to the mountains of Colorado because that's where I spend the hot summers. And in the winter, you can meet me in Scottsdale, Arizona.
All right, good to know. We'll definitely look forward to hopefully meeting one of you guys here soon. So
Yeah.
if you guys ever make it down to Texas, would love to see you guys. Definitely come down to Houston. It's the best part of Texas. The rest of
Oh,
it's
good.
fine. For all
I
our
do come to
Dallas
Houston.
friends, but
I stop for fuel in Houston all the time when I fly. So
no, please, definitely would love to meet you guys.
yeah.
So thank you guys very much. Awesome information. I know people loved it. And with that said, Pal, you want to take us away and kind of let's break it out to breakout. So as we like to tell people, your network is your net worth in real estate. It's really about who you know, who your team is, from, you know, your attorneys for help with asset protection to your CPA to everything in between. So networking is a critical part of this business, and you know, something you never know who you're going to meet, right? I mean, I met my partner at a networking event, and so it's definitely a good way. And we like the breakouts because you kind of get in a smaller environment and get to know the other people in your group. So stick around, and we'll go ahead and get the breakouts going.